May I proceed, Your Honor? May it please the court. It is an honor to appear before this honorable court to represent the prosecution in the matter concerning Mr. Mohammad Nizam. I am Dua Heather, counsel for the prosecution, and I'll be addressing the bench on the first and third charges as per the case record for the initial 15 minutes. Dua Heather. Dua Heather. I'll be addressing the bench on the first and third charges as per the case record for the initial 15 minutes. My co-counsel, Ms. Arisha, will then address the bench on the second charge for the remaining 8 minutes, and we respectfully reserve 2 minutes for the rebuttal. Assisting the prosecution as off-counsel is Mr. Umar, serving as the researcher. Your Honor, would the court prefer a factual summary? The case arises from political and ethnic conflict in Ashkar.
Not read. Extempore bolo.
Yes, but I'm reading the facts, so
Acha,
that's why.
you should know the facts. You should know the facts.
Yeah. The case arises from a political and ethnic conflict in Ashkar between Khalgari and Birani population. Elections occurred in November, and despite the alleged irregularities, Birani League secured majority, and before the transfer of the BLL leader died, and Khalgari party came in power under emergency. Soon after, one of the Birani leader publicly accused Mohammad Nizam responsible for their leader's death, which escalated the tensions. The region experienced 3 violent attacks targeting military infrastructure and state institutions. These attacks were attributed to Birani insurgent groups. And in response, the government launched a series of operations in Marra, where approximately 200,000 civilian deaths occurred, and Biranis were forcibly displaced and other violent acts. And on the basis of these facts, the prosecution has brought the charge against Mr. Mohammad Nizam for genocide, murder, and enforced displacement as crimes against humanity, while Mr. Nizam denies these allegations, asserting that these were counter-insurgency operations. Your Honor, may I proceed with my submissions? The establishment of genocide under Article 6 of the Rome Statute requires the establishment of 4 essential conditions, each of which is satisfied on the basis of the facts before this honorable court. Article 6 of the Rome Statute provides protection to 4 groups: national, ethnical, racial, and religious groups, giving rise to the first condition that the victims must belong to one of these protected groups. The victims in question here are the Birani civilians, an ethnical group clearly identifiable by their distinct linguistic, cultural, and historical identity. And this definition of ethnical group is also affirmed in the case of prosecution versus Akai Yesu at paragraph 513. Protection cannot be denied based on their political and social affiliations, so Biranis are protected as an ethnic group satisfying the first condition. Your Honor, this brings me to the second condition, which is the requirement of dolus specialis, or the special intent, which demands proof that the accused intended to destroy in whole or in part a protected group. As consistently held in international jurisprudence, genocidal intent is rarely stated openly and must be inferred from the totality of the evidence. This is also confirmed by the appeals chamber in prosecutor versus Christich at paragraph 34. Applying these principles to our case, the prosecution submits that Mohammad Nizam's genocidal intent is established beyond doubt through a conversion. Yes, sure. Sure, Your Honor.
Sorry, I do not know about others, but you are just reading things. Can you also explain this case? You are citing a case. Yeah. We have to go through it as well.
Sure, sir.
So please,
I'll give a pause. No worries. Apologies, Your Honor.
Please, you have to. You know the facts. We do not know that much.
Okay.
If you are citing a case, then you have to tell
I'll
us
give a
what are the
pause, Your
facts
Honor.
of this case which you are citing. Which is the first case you are citing?
I'm citing the prosecutor versus Akai Yesu. I'll pass the factual summary,
Is it
Your
about
Honor.
which country? किसका क्या था case? किसका case था ये? Which country did it occur this kind of thing?
Your Honor, it's in the ICTR court.
It may be, but I'm asking what the facts of this
I
case.
have passed on the facts. I'm not sure about the facts, Your Honor.
Why? You are trying to convince us to give in your finding in your favor. Then you should at least tell us what are the facts of this case and what was held in this case.
Your Honor, it's kind of impractical to know all the facts of all the cases I have cited, so that's why I have passed on the factual summary.
I don't know. Because इसके अंदर कुछ है ही नहीं, so I do not know. You're just citing a case. What is the evidence you have against Mohammad Nizam?
Okay, I'll cite the evidences now.
You show us the
Okay.
evidence, Ji.
Direct and circumstantial evidences established beyond doubt that he had committed those crimes. Your Honor, may I draw the court's attention to paragraph 57 of the facts and briefly take you through it?
Which para 57?
Of the statement of the facts.
Statement of the facts. इसका है ये?
No, Your Honor, that's the memorial. Statement of the facts.
The para 57. मेरे को 57 कहाँ है इसमें? हाँ? 57 कुछ नहीं है हमारे पास. ये तो fake facts मेरे पास भी है ना ये. 57 कहाँ है इसमें?
Para 57 of the moot problem, Your Honor.
दिखाओ. कहाँ है ये? मेरे पास तो है ही नहीं. ये वाला. मेरे पास तो यही है. इसमें 57 नहीं है. Sorry, I don't have this. ये इनके पास है, हमारे पास.
Your Honor, may I proceed on that basis?
Yes.
It explicitly states that the Birani problem must be resolved conclusively. If the separatist sentiment is rooted in their communities, then those communities must be broken entirely. Your Honor, it does not here speak of the individual insurgents, but it is explicitly targeting the Birani communities and state that those communities must be broken entirely.
Can you tell us the issue that it was, who was the government in charge? Mohammad Nizam?
Yes, he was the head of the state.
Listen to me a question.
Sure.
Don't jump. Huh? I'm asking you a question.
Okay. Apologies, Your Honor.
Yes, please. You have to listen to the question and then answer accordingly. Now, if these Birani people were separatist, they had a grievance. So what was the legitimate, Mohammad Nizam's government was a legitimate government or not?
Yes.
You accept that?
Can you repeat it? Sorry.
Was it a legitimate government?
It was an emergency, yeah, we can say
it was
that
a legitimate government. They
Yes,
were the
it
government
was.
in
Okay,
charge.
yes, it was.
They were the separatist
We
movement
were
by the
accepting that,
Birani
yes.
people regarding their grievances against their leader had died and etc. Things like. If there is a separatist movement and there are people who are fighting the legitimate government, so what should a legitimate government do to suppress that separatist movement?
Yes, but here the principle of proportionality comes in, Your
No,
Honor.
I'm just saying, what should they do? If they are separatist movement and they are fighting and they are bombing and etc. whatever things they are doing, what should they do then to stop this thing?
They should conduct attacks, but that should
Wait a minute, just let me write
proportional.
down. You concede that they should do it.
Your Honor, I really apologize, but you're not audible.
Under Article 6, there is a specific requirement
Yes, Your
of
Honor.
what a genocide is. Can you first tell me what is the context of Article 6 and how
Sure,
you
Your Honor.
relate Article 6 to the present situation?
Your Honor, the Article 6 of the Rome Statute requires first condition that it must be from one of 4 protected groups, and those 4 protected groups I've already established before the court. That
You
should
not
be
established anything yet.
Yes,
Point
sorry.
is that,
Apologies, Your Honor. That should be national,
Yeah.
ethnical, racial, and religious group.
No, but point is that my question, I'm again repeating, okay, what should the legitimate government do? And how does that amount to, as my learned senior
Okay,
judge was saying, how does it amount to genocide? If you're trying to suppress the movement.
Yes, they should conduct, but it should be proportionate, Your Honor. I want to cite other...
And how can a military action be proportionate? What do you mean by proportionate?
Your Honor, in the insurgent groups that were happening, that approximately 119 military personnel died, and in the second attack 112 died, and that is mentioned in the facts.
Let me ask you another question.
Sure, Your Honor.
When you say some act should be proportional to the act done by the other person, where have you said that it is not proportional and how it is not proportional to the act?
Okay, I'll establish on that, Your Honor. As I have already mentioned that approximately 19 and then 112. And in our case, that the operations that they conducted in Mara, that we are citing that those are genocide, the death toll in one operation were 6,500 individuals that killed, approximately
Aisa,
6,500.
please, you are going too
Okay,
fast. Just relax. We are not.
No,
don't
no
worry.
worries, Your
We are
Honor,
listening
there.
to you. Aisa bole, then we can.
Okay, there were 6,500 individuals that died in the operations that they conducted in Mara. And out of them, only 112 were confirmed combatants, Your Honor. And those operations that they have conducted in Mara, that were based on unverified reports.
When you say unverified report,
Unverified
what you are
intelligence
saying
report.
basically is that the incumbent government does not have any knowledge and therefore they proceeded on unverified reports.
Yes.
How do you say that?
That's mentioned in the agreed statement of facts, Your Honor. Should I cite the fact?
Yeah.
Okay. It's paragraph 42 of the agreed statement of facts, Your Honor.
Page?
Page 10.
ये हमें देना चाहिए था, आपने भेजा नहीं था ये हमें.
नहीं, ये तो पहले नहीं आता. जी, page 10, okay. और paragraph?
42, page 10.
Yes, my assertion was that those attacks were based on unverified reports.
Where is it said?
Several villages reported that soldiers opened 42, sir. ये वाला है.
Yes.
Second, ये इसका वाला.
42.
Yes, Your Honor.
Okay.
May I proceed with my...
What you are
yes.
saying is that people had not gathered. This 42 says that received unverified intel of armed gatherings. Now, were there people gathered there or not? How will you say it is unverified if there were no people there?
That's exactly my assertion, Your Honor, that those were unverified reports, and despite that, they conducted operations in Mara, and unverified, they conducted such a large-scale armed assault there, and the death toll was 6,240 people, and the confirmed combatants were 112 only.
But you say they are unverified. So how
Yes.
was this figure verified?
They should have...
No, you're saying unverified reports.
yes, these were
If they're
unverified.
unverified, then how have you come to the conclusion of these reports that there were only 117
Yes, so
combatants?
we are asserting that it was genocide through these facts, and they asserted that
Okay, I'm just
the
saying
defense...
what is this unverified? What's the verification that these people died?
These are agreed statement of facts between both the prosecution and defense, so there is no contradiction between it. So Your Honor, further they asserted that these were, and at paragraph 51, that these were precision elimination missions. Your Honor, the nature of the weapons that were used completely undermine this assertion. We could see at paragraph 38 and 51 collectively that they used paragraph 39 and 51 collectively, that there were use of tactical bombers and 500 kg unguided fragmentation bombs. So the
But
weaponry...
Do you agree that the insurgency was started by the Birani people?
Yes, we do agree.
Armed insurgency?
Yes, we
You
do
concede to
agree.
that?
We concede to that.
ठीक है. If there was armed insurgency and these combatants were hiding within civilian population, so and they were using the civilian population as human shields, then how can you draw a distinction between combatants and civilians? Can you please explain this?
Yes, sure, Your Honor. Can I get more clarity on your question?
My clarity is that if they are unverified reports, if these combatants are hiding within the civilian population, using them as human shields, probably, if they are insurgency going on in those areas, and the government is legitimate government, as you conceded, is taking action, how can you say that there was genocide?
Certainly, Your Honor, my assertion is still the same, that those were not proportionate.
Your assertion may be same, but you have to convince us. Your assertion
Yes.
may be same, but you have to convince us.
Yes, okay,
Ji.
I'll try to do my best. Your Honor, if they cannot conduct such a large armed assault, that too in a densely populated area with such weaponry. They have used napalm canisters, and those were mostly unguided munitions, and that too in a area where there was unverified reports. They cannot do such a large armed assault, and those were not
So
proportionate.
how do you say it's genocide?
It's genocide because we have documents
Nee,
where
what's the definition of genocide?
genocide
Under
ethnically.
the Roman law,
Okay,
under the Roman statute.
I'll read it out for you. It requires that the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, and a religious group.
Was
Killing-
it to destroy a nationality, or was it only confined
was
to stop the insurgency?
It was ethnic cleansing.
No, it was ethnic cleansing, or was it just try insurgency to stop the insurgency?
No, it was not insurgency. We don't believe it's insurgency, and this is the main submission of the prosecution.
So then there was no insurgency, and they were just going to
No.
killing these people like
Yes.
this. You first said that there was insurgency going on.
Yes, actually, you agreed that there was
It's insurgency, yes.
Yeah, but Your Honor, an intent can further inferred during the operation.
In Article 6.
Yes, Your Honor.
In Article 6, there is nothing to say that there has to be something which is proportionate. If an action is taken against a group of people who have acted against the legitimate government, how will you bring that action under Article 6 of the...
Okay, Your Honor, am I allowed? Okay. Your Honor, we have documents where Prime Minister Mohammad Nizam himself has acknowledged that he was targeting Birani communities, as I already cited it in the beginning.
Civilian population?
Civilian population.
Where does it show? Show us. Where he has admitted to that he is targeting civilian population. Then you may have a case.
Sure, Your Honor.
Show us the paragraph where you saying.
It's paragraph 57, which I cited, and then we have 59, 57 and 59. Should I read that out for you, Your Honor? Your Honor, the language clearly goes far beyond counterinsurgency. And we also have paragraph 59.
This does not say anything of that. 37 does not say anything. 51.
You can have 59, 57
15.
kya hai na? Ke matlab they should be 57. You cannot allow people to reject the state to survive.
नहीं वो तो है 57. Yes, what it says is that the Birani problem must be resolved conclusively. It does not say that how they will be resolved. If they are also armed, and the government is also armed, and the government is legitimate, then they are naturally the government will have more power and authority than what an armed group would have. Why should a group of people challenge the government with arms and ammunition, expecting that the government will not react or retaliate to that action?
Your Honor, I'll answer that in two parts. Firstly, this document never mentions that it was insurgents. He said Birani problem must be resolved conclusively. And secondly, that just because in a community there are insurgents, you don't have the right to... It is not justified that you would wipe out the entire community just to target the insurgents.
Thank you.
Thank you.
Mr. President, Your Honors, may it please the Chamber. My name is Aisha Ismail, counsel on behalf of the prosecution, and over the course of next 8 minutes, I will address count 2 of the indictment that enforced displacement occurred between February and September 2024 against the Birani civilian population constitute enforced displacement. Your Honors, it came into my attention that the Honorable Chamber was confused on the facts of the case and was
Sorry,
inquiring.
we are not confused.
Was inquiring
I
the
think,
factual summary.
You may be confused, but we are very clear in our
I would request the Honorable Chamber to hear the
I don't think
clarification.
the confused word is proper.
I would require the Honorable Chamber to have further clarification on the facts so
Yes,
that
please,
it is
Kenny.
easier.
Yes, please give us.
Much obliged, Your Honor. So there was this province of Marra which constituted 70% of Birani civilians. And the defense alleges that the operations that we were conducting were towards militants that were blurred between the civilian populations. However, as a result of those insurgencies, the death toll that arise, I would require the Honorable Chamber to bring your attention towards fact number 37 of the case. It mentions that 189,762 civilians, Birani civilians, lost their lives as a result of operations. So they cannot allege that these were militant operations when the people who were losing their lives were actually Birani civilians, were actually belonging to a certain ethnicity.
Can the civilians not be people who challenge the government through arms?
Much obliged, Your Honor, but the civilians in the case at hand were innocent. They were innocent people residing in their ancestral towns. For that purpose, I would require the...
Has it been said that they are innocent? Innocent is a very difficult word to explain, yeah.
Much obliged, Your Honor. For that matter, I would request the Honorable Chamber's attention to fact number 49 of the case, where it clearly mentions that the Birani civilians were residing in Lidhar, Guzra, and electricity was cut off and water blocked and access. This clearly proved that they were left out, that they were left alone, and they were at the mercy of the injustices happening at the end of the defense.
Read 48 first.
Villagers reported soldiers fired homes indiscriminately. And Your Honors, your concern is valid.
Reports of hidden weapon cache. What does that mean?
Could you please refer to the page number that you...
Page number 11,
Page 11.
47. And 48, sorry. 48.
Yes, Your Honor. It is to bring in your kind knowledge that villagers recounted that soldiers fired indiscriminately. And the villagers here are exactly what we are
Please go ahead.
asserting,
Please.
that these were Birani
No,
civilians.
please go ahead, read the whole.
Imaged indiscriminately into homes after receiving intelligence reports of hidden weapon caches.
Yeah.
The ANA recorded 98 firefights, but aerial and satellite imagery later revealed that only 19 actual militant encampments were there. And Your Honors, 19 compared to 189,762 civilians is a way large scale. And it is a downfall at the end of ANA itself, because...
Was there deliberate action or orders to eliminate the civilians? Can you show us any order?
Much obliged, Your Honor. Your concern is valid. For that matter, I would request...
Dua, just show us some paragraph. You read it again, please.
I would request Your Honor to bring your attention towards para number 57, para number 58 and 59 of the case of the moot problem, where it clearly states that the ANA commander was receiving intelligence. The Prime Minister, in fact number 59, was receiving internal briefings, and yet commanded proceed. Birani civilian members are irrelevant. If area is secured, do not delay operations and proceed with Birani losses. If Your Honors could bring their attention towards fact 59 of the case. It clearly mentions that Prime Minister himself commanded to proceed with Birani civilian losses.
So it says the area should be secured. National integrity should be maintained. So,
Much obliged, Your Honor, but the national integrity could not be maintained with just 19 militants residing inside 189,000 civilians.
But how does one identify which are those 19 in a population of XYZ numbers.
Much obliged, Your Honor. But it is imperative that a state that is investing that much finance into administration into conducting insurgencies and operations must have enough finance to identify through aerials, through satellites, that who were civilians and who were militants.
But the basic issue is that these insurgents or the 19 armed people or the teams were actually hiding within the folds of those communities. Like it could be any civilian living there. How does one identify?
Much obliged, Your Honor. So it is a downfall at the end of the state of Ashkar and the government of Muhammad Nizam that they should have taken adequate measures as being a civilian responsible under Article 28B of the Rome Statute, which clearly states that a civilian responsible, if he expresses inaction in such a situation and fails to repress or suppress crimes, he is responsible under international law for under the garb of civilian superior responsibility.
No. Read Article 6B again, please.
Much obliged, Your Honor. Although my issue concerns with enforced displacement, which I have not started yet because I have been explaining you the factual summary, and this concerns with genocide, which was my first counsel's.
I have asked you very specific. Read Article 6B.
Article 6B you are referring to? It says that causing serious bodily or mental harm to the members of the group, and this is one of the requirements to constitute genocide, and that is exactly what we are intending.
Genocide has to be the intention of creating a genocide. But if someone is going against the government, then will that amount to genocide?
Much obliged, Your Honor. But if you look at the factual assessment of the case, there is no paragraph that maintains that Birani civilians were going against them. It was rather the state of Ashkar that stated those were a harm to the state integrity. For that matter, I would request the Honorable Chamber to bring your attention towards.
What do you mean by serious bodily harm? What constitutes serious bodily harm in your case?
Much obliged, Your Honor. Serious bodily harm constitutes injuries that are severe that might end up a person losing his life or deteriorating his overall physical condition. That is all what amounts to bodily harm. If Your Honor grant me 2-3 minutes,
Any case law on that?
Much obliged, Your Honor. We have the case of prosecutor versus Bosco Nataganda, judgment para number 1097. I would request the researcher to pass on that to the Honorable Chamber.
Do you have any case law? Do you have on case related to Bosnia and Herzegovina? Are you citing any case on that?
Much obliged, Your Honor, but the case at hand does not concern with matters pertaining to Bosnia versus Herzegovina. However, that concerns.
I'm just saying, your situation, the case you are presenting before us, two similar situations do appear. One is the Rwanda issue.
Thank you.
The cases of Rwanda, and
Yeah.
second is Bosnia-Herzegovina. So the only thing they found was Srebrenica massacre was regarded as genocide, not the rest of the attacks by Serbs on the Muslims and Croats. Or there was no genocide in the war between Serbia and Croatia. Do you have case law on that?
Much obliged, Your Honor, but it is merely the reason because genocide in international law is very hard to prove because it is a very open-ended crime that requires a lot of.
Proving in Srebrenica massacre.
Your Honor, could you please repeat your
In
assertion?
Bosnia, they were able to prove it because there was genocide by the Serbs. They were able to prove in the Rwanda issue, the Tutsi and the other one.
Much obliged, Your Honor, but the Council has not relied upon Bosnia versus
Which case are you
Netherlands.
relying on? Which area are you relying on?
We are relying on the state of Ashkar and
No,
the conflict that happened.
Okay, I know you're trying to prove, but are you backing up your arguments with any case law in other situations?
Your Honor, I would like to bring your attention for that matter to Memorial, page number page number 21 in the memorial for prosecution, where it clearly states that the force
कौन सा ये? Memorial?
Memorial ये वाला, लाल वाला.
memorial, page number 21,
जी.
which states that in the case of International Criminal Court concerning prosecutor versus Bosco Nataganda, para number 1069, lawful presence does not require formal title or registered residence. In addition, and it habitually suffices to constitute civilian residence.
These are talking about enforced displacement. I'm not talking. I'm talking about massacres, not displacement.
Much obliged, Your Honor, but my submission at this moment concerns enforced displacement, which I have not yet been able to
By the
confirm.
way, 6D says there has to be a massacre, there has to be something which gives bodily harm, not displacement.
Your Honor, your concern is valid. You are saying massacre, and the case at hand presents.
अपना केस बताएं. Enforced displacement का बताओ.
Much obliged, Your Honor. I would now like to proceed towards my submission.
Yes.
My first submission is that enforced displacement occurred unlawfully and forcibly. For that matter, the forcible displacement of approximately 480,000 Birani civilians from Mara province constitutes enforced displacement under Article 7, subsection 1D of the Rome Statute. The Biranis were lawfully present in their ancestral towns as asserted by me previously, which is also further corroborated in fact number 55 and 56 of the case and has been held by International Criminal Court. Furthermore, Article 50, subsection 1 of Additional Protocol 1 to the Geneva Conventions, which is the relevant
For
lex.
example, if there is genuine military action taking place against separatists, there has to be internal displacement of people. You are refers to IDPs. How is that means forcible displacement?
Much-
Actually, that may be for the safety of those civilians.
Your
So how are
concern-
you saying they are enforced displacement?
Your concern is
And
entirely
even if there
valid.
is enforced displacement for the safety of those civilians, your case you are making out is genocide. Now, if those civilians are being asked to leave a active military zone, then how can you? The senior president is a retired army officer and fought the 71 months, so he knows what internal displacement etc. is there. So
Have you read the Rohingya case where there was a displacement? It was held that it did not amount to genocide.
Much obliged, Your Honor. The issue at hand, the issue that I am submitting towards this honorable chamber is of enforced displacement, and the genocide submission was of my counsel, and we have not been able to overlook all the facts at hand, all the cases that are present and the key precedents at hand. However, to your assertion that the residents lost their lives and enforced displacement has to incur, Your Honor, there comes into play under customary international law the principle of proportionality.
Arisha,
Much
you're
obliged, Your Honor.
your time has already been over. How long do you need to explain your point?
It depends on the honorable chamber. If you could grant me
you should
2-3
say as long
minutes.
as it takes us to convince us.
No, but there is time limit involved here. So if you can finish it off in the next
It's
180
completely in
seconds.
the honorable chamber's discretion. If you,
हाँ, खत्म करें.
I would now like to conclude my submission of that unlawful and forcible displacement occurred for Birani civilians under Article 7, subsection 1D of the Rome Statute. Muhammad Nizam, who was the authoritarian of the government and the Prime Minister of the state, is responsible under Article 28, subsection B of the Rome Statute. And the forcible displacement was also discriminatory under Article 7 of the Rome Statute. And
what you are mentioning in this memorial, that they were prevented from returning. Is that correct?
yes, Your Honor, they were prevented from their returning.
All times to come.
All times to come.
Where did they
They
go?
were evacuated from their homes, and then the villages that they were residing in were destructed in their entirety. And the people that were that were directed towards containment zones had been electricity blocked, water blocked. For that matter, I would request the Honorable Chamber to bring your attention towards fact number 49 of the case, where it clearly mentions that electricity was cut off, water was blocked, road access was blocked, and furthermore, in fact number 56. There was destruction of agriculture, homes rendered. This all rendered it implausible for the people to return back to their ancestral homes. For these reasons aforementioned, I would now request the Honorable Chamber's permission to allow me to proceed towards my conclusion and prayers.
Yes.
Much obliged, Your Honor. On the grounds aforementioned, We submit that unlawful and forcible displacement occurred against Birani civilians. Secondly, discriminatory forced displacement as a part of widespread and systematic attack and state policy occurred. And lastly, civilian superior responsibility of Muhammad Nizam under Article 28, subsection B of Rome Statute is there. Therefore, the prosecution prays before this honorable chamber to declare that the crimes committed between September 2024 constitute enforced displacement, and Muhammad Nizam bears the liability under the garb of civilian superior responsibility and the principle of ubi jes ibi remedium, which states that where there is a right, there is a remedy, the right being the right of Birani civilians in the case at hand. If your honorable chamber is convinced, may the council leave the floor.
We are convinced. We'll decide that later, but well argued.
Much obliged.
Thank you.
Thank you.
Mr. President, Your Excellencies, and may it please the court. My name is Aisha Bukhari, and my team code is OST 13D. Together with my co-counsel, Ayan,
What does OSTD 13 mean?
OST 13.
Huh?
Team.
Team. Acha,
Team.
okay.
Together with my co-counsel, Ayan, I represent the defense.
Okay.
For the next 8 minutes, I shall address count 1 regarding genocide, and my co-counsel will address count 2 and count 3 regarding the killings and enforced displacement. We shall reserve 2 minutes for sir rebuttals. Your
Yes,
Excellencies,
please
I shall
proceed.
certainly. Your Excellencies, I shall be dividing my submission regarding count 1 in 2 subparts. First, it is our submission that the attacks do not constitute genocide under Article 6A till subsection 6C of the Rome Statute. And on the second, that Prime Minister Muhammad Nizam cannot be held responsible for genocide as a civilian superior under Article 28B of the Rome Statute. Your Excellencies, as regards to my first submission, we put forth that the attacks were not targeted at a protected group, and on the second, that the physical elements of genocide are not established, and on the third, that there is no evidence of genocidal intent. I shall address each of these elements of genocide under Article C in turn. On the first, as regards the first element, it is our submission that the attacks perpetrated were not towards a protected group. Your Excellencies.
What do you say about the leaked memo referred to by the prosecution that you said to remove them? And can you see para 57 again?
Certainly, Your Excellency.
How do you explain that?
Your Excellency.
Yes, 57.
Yes. As regards paragraph 57 of Statement of Facts, we acknowledge the use of the words to remove them from the land if necessary. However, in this, for the Commission
And read it, please read it and read para 59 as well.
Certainly. The Birani problem must be resolved conclusively. If the separatist sentiment is rooted in their communities, then those communities must be broken entirely. We cannot allow people who reject the state to survive within it.
Please stop here. What do you mean by that?
Your Excellencies, the
You-
League Minister
we
Directive.
cannot allow people who reject the state to survive within it.
Certainly, Your Excellency.
Doesn't
This-
that amount to an order for exterminating those civilians?
Your Excellency, for genocide, the requirement is for the intent to destroy the people for the reason that they belong to that particular protected group. In the specific reason,
What is a protected group?
a protected group, as regards, as mentioned within the strict definition of genocide under Article 6 of the Rome Statute, must be racial, national, or an ethnic group or religious one.
So how are they protected? Because they are part of Ashgar state. How are
Yes.
they protected? They had launched a separatist movement.
Certainly.
It was the government's duty to bring peace.
Certainly, Your
They,
Excellency.
they may have used methods which were beyond proportionality, as they were saying, the prosecution was saying. But how do you say that to survive within the state? What is the meaning of that?
Precisely, Your Excellency, the prosecution did establish the fact that they were an ethnic group. Our position here is that although we acknowledge the presence of killings, we acknowledge the presence of destruction. in the present case, there is no intent to destroy the group or to commit the killings for the reason of them belonging to an ethnic group. Rather, it is because of the political
You
insurgencies.
acknowledge this fact that they were exterminated in your order, and the order of Muhammad Nizam was this: reject the state to survive within it.
Your Excellencies, we acknowledge the fact that there were destruction that occurred because of the political insurgencies that were launched
And
by the
then,
inner forces.
remove them from the land if necessary. So, ये displacement भी हो गई.
Your Excellencies, as regards
And make Mara inhabitable for those who defy Ashkar's unity.
So, precisely, Your Honor, this statement that for those who defy Ashkar's unity proves that it is not because of them belonging to ethnic group that is Birani.
So that is okay for them to exterminate them if they not belong to any racial or ethnic group. If they are Birani people, they belong to a community. They
Yes.
are different from you.
Yes.
They constituted majority in the Birani area
Yes.
before you declared a unitary state.
Yes, Your
So
Excellency.
how do you say that they do not belong to a separate group?
Your Excellency, in the present case, although we acknowledge that Biranis were a separate group and they had their own majority state, wherein they had a majority population of 70% Biranis, yet in the present case, because there were attacks arising from that region, the attacks were launched as an insurgent attack.
I'm sure my all the learned brothers and sisters are accepting that you have a legitimate right to suppress. But the question here is, was it your policy to exterminate those civilians, to make it uninhabitable, those area Mara? You say that in your leaked internal memo. How do you justify that?
Your Excellency, as regards the leaked ministerial directive, the use of the words defy Ashkar's unity proves that the extermination or the killings or the attacks are directed not towards the community, but rather towards the arising attacks from that region.
No. Please, again, you say that it says we cannot allow people. You don't say about combatants or armed groups. You say we cannot allow people who reject the state to survive within it. And all the Barani people had rejected your unitary government. So you cannot discriminate between civilians and the combatants. They were genuine people trying to fight for their independence, for example. If they were fighting for their independence and wanted Barani a separate state, you went in with forces and disproportionate use of power, force to subjugate them. How do you justify that?
Your Excellencies, in the present scenario, it is our position that the attacks that were launched were not because of them being Birani, but rather
Who started these attacks?
the Birani.
You started, no? You are defending thing, huh?
Your Excellencies, we are defending Muhammad Nizam as the Prime Minister of the state.
Yes.
It is the prosecution who is protecting the Biranis.
Yes.
And
But I'm saying that Birani started it. Okay, fine. But you went in to subjugate them. Probably they were asking for independence. They didn't want to become part of your thing. Aren't they entitled to have their own country or something?
Your Excellency, in the present scenario, as well as in context of paragraph 57 that Your Excellency is raising the concern about, the fact is that because of the fact that Biranis were using their own population as human shields, the fact that Biranis were using...
That's the word I used. You did not use. I used the word. I asked them a question. They were using as human shields.
It is mentioned in the statement of facts.
Is it mentioned as a
Yes.
human shields? Can you
Yes.
show me? Sorry, I didn't see that.
Paragraph 40,
40.
on page number 10 of the statement of facts.
Show me which para?
Paragraph number 40, last line states, civilian losses, if any, were the result of militants using human
Okay,
shields.
sorry, I didn't see this. Okay, thank you.
Your Excellency, it is
What is the difference between a freedom fighter and a person who was fighting against the state? There is a difference between a terrorist and a freedom fighter. How would you distinguish the two?
Your Excellency, if I understand correctly, you're asking the distinguishment between military objectives and civilians. Certainly, Your Excellency, in this regard, military objectives would be any civilian wherein there is a threat posed or there is an possession of armed weapons, there would be a threat to the military.
But the issue is that they were separatists. They were separatists. They were freedom fighters. How can you charge a freedom fighter as a terrorist or otherwise? Can you do that?
Your Excellency, I see that my time has lapsed. If I may
Don't worry,
answer your
you
question.
Don't worry about that. Answer the question.
Certainly. Your Excellency, in regards to the Biranis having a separatist movement and launching attacks, in the present context, the attacks that were launched by the forces of the state were not targeted because of the fact that they were Biranis and because of the fact they were freedom fighters, but it was just to aim to pursue security and restore peace in the state. Because of the fact that
Peace according to your terms of Mohammad Nizam.
yes. Your Excellency, the state agreed in the statement of facts that all this that the Biranis were using their civilian roof, their civilian houses, civilian settlements, and had their armed weapons hidden between them.
It was Nizam who stated this. Can you read para 40 again? It says, Nizam dismissed independent inquiry stating civilian losses, if any, were the result of militants using human shields. It was you who were saying that, not the independent groups were saying something else. They say government briefings claim that aerial surveillance detected movement of armed Birani separatists in an abandoned grain storage facility.
Your Excellency, we shall be relying on the statement of facts that are agreed here. It is true that it is a statement of our own Prime Minister.
But we want to be satisfied.
Yes, Your Excellency, we agree with the fact that this reliance is based on Mohammad Nizam's own statement. However, there
now
are
you
other
accept that it was his statement they were hiding human shields. It was not the Birani people saying that.
Your Excellency, for that we can rely alternatively on paragraph 46.
Which is?
Which states that there was government later issued statement claiming that drones detected armed Birani snipers and ordnance depots integrated within civilian structures. This proved that there were armed Birani snipers that were within the civilian structures. Your Excellency, as it is a principle of international customary law that in circumstances where the civilian structures or civilian homes and settlements are being used for military purposes, an attack can be launched against them for the reason that they are irrelevant.
Which article says that? Because this is the excuse Israel also uses against the Palestinians all the time, which the international community, United Nations rejects. Sorry.
Your Excellency, this is a matter of, this is principle rule 10 of the CIHL, and in the present scenario, we like rule 10 of customary international law. However, we like to distinguish this case from, Your Excellency, if I may distinguish the present case from the Israel scenario.
Read rule 10.
You have rule 10?
I do not have the copy, but I can read it out.
Can somebody take it out, rule 10 for us?
Rule 10 of customary international law states that civilian objects are protected against attack unless and for such time as they act as military objective. For a military objective,
There is a military objective.
yes, sir.
Military objective is to stop the insurgency.
Yes.
The insurgent says we are freedom fighters. How do you distinguish the two? I've been asking this question quite a few times. As a government, you say they are insurgents. They say they are freedom fighters. Now, once they are freedom fighters, Rule 10 does not apply.
Your Excellency, the prosecution did concede to the fact that there was insurgency in the present case. Alternatively, we submit the fact that although Biranis were freedom fighters, in the present case, that does not allow them to use their homes, their civilian structures as to present in front of the military.
By the way, your argument goes contrary to 57 of the facts on page 12.
Your Excellency, I will respond.
No, that is what I'm saying. When you're referring to Rule 10, what you're basically saying is that you want to stop the insurgency.
Yes.
Right?
Yes.
Now, but here it says, remove them from the land if necessary. What does this goes exactly against your argument?
Your Excellency, I respond in two parts. First, this directive is a leaked ministerial directive.
But you accept it, no? This is leaked from your office.
In case that the court does find it to be
Keep in mind that this was not just leaked, this is the facts of the case that both parties have agreed upon. So these are the agreed facts. It's not anything unusual.
So it's leaked from your Nizam's office.
Yes, precisely. Your Excellency, for that, I would respond to your question, stating that although we acknowledge the fact that there is, this does state that it is because of Biranis being freedom fighters. In this case, freedom fighters do not.
Go ahead.
freedom fighters do not kill and do not launch attacks against the armies. Freedom fighters do not
Freedom
cause.
fighting or karenge kya? I mean, how do they fight? They have to launch attacks. For their independence, if Irani has been by force incorporated into your state, so they have a legitimate right. Don't they have a legitimate right to,
Your Excellency,
to struggle or armed struggle against for independence?
Your Excellency, there is no evidence of peaceful protest in the present case. The Biranis, insurgency.
No, we accept that Biranis did launch a thing, but they launched it because of your unilateral actions of Nizam government by making it a unity state. Do you accept that? That this was a direct result of your actions, that the Barani people launched this movement.
Your Excellency, if I may direct the court to paragraph 19,
Of
the statement of facts.
G.
His reading from second line, it states, his tone sharpened as he declared, but the reason we are all present here is for something more pressing. The crowd quieted. He then raised an objection above his head, an injection syringe, claiming it had been retrieved from Mr. Nizam's room. Mir-Raza did not pass away naturally. He has been murdered. Your Excellency, this is a statement from Raza, who was a...
It can't be from Raza. Raza is dead.
Yeah.
Raza to mar gaya tha. Uske log-
This is a statement from Hassan, who was representing the Biranis. In this statement, he mentions and he's expressed statements that would incite the Biranis and the population
Is
to...
it a fact that Mir Raza had died in mysterious circumstances?
Yes, it is a
It was
fact.
their leader, and the autopsy was not carried out.
Yes, Your Excellency.
ठीक है? So then they had this ground for suspicion that Raza had met unnatural death.
Yes.
They had a condition for that. The state had a right to disprove them, but they didn't. So they have a legitimate right to protest against that.
Your Excellency, even in that scenario, it does not satisfy, it is not reasonable for the Biranis to launch attacks directly just because of the only evidence being there of his presence
It's
of...
not only evidence of Raza's death. Raza's death was the final nail in the coffin. The first thing was the unity state, the denying the Barani people their rights.
Your Excellency, the aim for a unitary state was because historically it had been one state until for the British colonial rule. The only reason and aim for a unitary state was to reject the fact of duplicate governments.
Did Barani people agree to this unification?
They did not.
They did not. So you cannot claim that it was because you imposed your will on them. Is that correct?
Your Excellency, yes, we do accept that.
You do.
We do accept the fact that there was a unity required in the country.
No, you didn't. You said you accepted that it was your actions which made it. You're not unity. How can there be unity when the other party is rejecting the unity? How do unity can be between two people or three people or something? How can have unity when one is rejecting the unity state?
Your Excellency, Biranis did have their own majority states such as Marra,
It's not a matter
Zarna.
of majority. They had a majority area which you incorporated. You are referring to 3 districts or whatever. That's all. This is an ideal case of that the Gharo Karabakh in the dispute, Azerbaijan dispute.
Yeah, Your Excellency, for this we submit the fact that although we accept the fact that there was that Biranis did deserve a right to a separate state, for the purpose of genocide, there was no evidence in the present case that there is an intent to eradicate Biranis.
I
Just
think
the
para 57 is very. Somebody or your colleague has to explain to us para 57.
Your Excellency,
With
we
my
can
view, I don't know.
we can compare this to different other cases within the Rwandan genocide case, wherein the use of the word "let's exterminate them" was used. However,
it's not
in
a
the
matter.
present,
In criminal law, it's not only the matter but use of word; it's the intention. You have to prove that you did not have the intention to carry out genocide. You did not have the intention to force displacement or crimes against humanity. You have to prove. Prosecution has to prove beyond all reasonable doubt that Nizam had all these things. You just have to show that he did not have the intention. The burden is not on you. Burden is on them, and we'll discuss whether they have satisfied that burden or not. But you have to show that you did not have this thing. What they are saying is wrong.
Your Excellency, for which we can for intent to be gathered, we can rely on the Al-Bashir case, wherein it was categorized into 3
What is
subcategories.
Al-Bashir case? I do not know.
Al-Bashir
about it.
case was in the
Which
ICC.
country was it?
It is from the ICC. It is the ICC
वो
case.
तो केस होगा लेकिन which area did it? कहाँ का
It's in
अल-बशीर?
Sudan.
सुडान का.
Yes, Your Excellency.
अच्छा अल-बशीर वो कहाँ ठीक है.
Yeah, Your Excellency, in the
Umar Hassan al-Bashir. ठीक है.
yes, Your Excellency, in the case, in Al-Bashir case, there were three categories that needed to be submitted. That was firstly the statements and officials, secondly the context of the attacks, and thirdly the nature and extent of these attacks. These three categories together and collectively can be used for to demonstrate
What
the
was
intent.
the finding in this case?
Genocide was not established.
Not
No,
separate.
just
Yes,
just
despite-
no. It was in this case what had happened basically is that they said Article 6 for the purposes of genocide, the contents were not sufficient to hold that there was a genocide. And this is the case. Now, when you say that this is not the case, therefore you have to now show that the action that you had taken was, or that they had proceeded either way, was not sufficient to make it a genocide, or you could show to us how it amounted to genocide. See, this judgment, in that judgment they held that there was no genocide because the conditionalities of Article 6 is very harsh and very... So how do you say that this judgment would help you?
Your Excellencies, on the first page of the judgment submitted, it states that there were numerous attacks that were carried out, which were systematic attacks against.
Yeah, I know. Despite all that, they held that it was not genocide.
Yes. Yes,
So-
exactly.
So you are saying, what you are saying basically is that the conditionalities that were there were not available. Here, their argument is that the conditionalities were there because you removed them, displaced them. For 9 militants, you hit the civilian targets. The intention was to remove them. This is what their case is. Now, this is not a case where it was so, because here the intention was totally different. Intention was not to remove them, the intention was not to kill them totally. The intention was to curb the
Insurgency
uprising.
and the
Or,
uprising and the armed
that,
combat.
in that, if you read 57, you said remove them, control them, fire them, etc., etc., etc. Now, what does this mean? Because this judgment is otherwise not helping you because it is very different on facts.
Your Excellency, the parallel we draw from the Al-Bashir case is that despite the large number of killings and despite the fact that these were directed at specific
No,
towns
just
of...
a minute. Large number of killings does not amount to genocide. Agreed.
Yes, yes.
But here in para 57, you have categorically shown your intention that you do not want these people anywhere near you. Then what is this? What does this mean?
Your Excellency, for this, if we focus on the text of the intention that is required in Article 6, it states the intent to destroy in whole or in part a national, ethical, racial or religious group as such. For this, there's a reason that the intent...
That is why I said the Rohingya case, they did not hold it was genocide, despite the fact that they were removed from their...
Displaced as well.
Forced displacement था वहाँ पर. There was a mass killing. People had to move out. Despite that, they said no. This was not genocide. Now, I think you conclude your argument.
Your Excellency, to respond to this question...
Conclude
Your
your
Excellency,
argument.
to respond to and to conclude my arguments, I submit that it needs to, for the intention, it needs to be against Biranis for the reason of belonging to that group. In the present case, it is for the reason of being insurgencies. Although they are from the Birani group, however, the target is not because of the fact that they belong to that group specifically, but rather because of the fact, not because of the support of the Biranis, not because of the fact that they were a separate group, not because of the fact they were freedom fighters. It is because and only to launch and to counter-surge the attacks that were being launched in the strait. It rather pursued the aim to restore security in the region, and it is not possible to deduce a genocidal intent against Birani specifically in the present case.
Thank you.
Thank you. Thank you.
It was an honor pleading before this court. Thank you.
Well argued.
May it please the court. My name is Ayan Khan, and I'm honored to appear before you representing the defense. And I'll be assisting this court on the matter of count 2, forcible transfer, and count 3, which pertains to murder under Article 7 1D and 7 1A. Honorable judges, firstly, I would mention the criteria for both of the counts under Article 7. Article 7 of the Rome Statute requires, firstly, that the contextual elements have to be proven, which means that there has to be an attack on the civilians. Second, that there has to be knowledge of the attack on civilians. Thirdly, that it is pursuant to a state or organizational policy, which means there has to be a policy of the state to attack the civilians. Honorable judges, if the contextual elements are dissatisfied, the count for forcible transfer and murder both are disproven, or charges would not be confirmed. Honorable judges, firstly, arguing that the attack was not directed against civilians. We note that the insurgency which was incited by Hassan Ali, which led to terrorist attacks that killed 140 military personnel and 10 civilians and caused significant infrastructural damage.
Where has this been said? What paragraph?
Statement of facts, paras 22 to 23.
This does not give any figures.
But is the figures are given?
23, subsequent investigation determined by the individuals had placed 2 explosive devices on the bridge of structure. First device was positioned beneath, etc., etc. Those are. How do you connect this to insurgency and not separate?
Honorable judges, there were 3 attacks. The paragraphs I would mention is 22 to 33. So there are 10 pages of attacks merely. And
What is being said basically is that they were using arms, they were using ammunition, they were using this. All that is true. But how do you determine that this was not a separatist movement, it was an insurgency or some other movement?
Honorable judges, why I would mention that this was not an occurrence of freedom fighters and it was of terrorists.
What is the difference between a freedom fighter and insurgent?
The freedom fighter protects their people and is fighting for a particular group or organization to get them freedom.
Here, were they not protecting their own people?
Honorable judges, we mentioned that nowhere in the attacks which occurred, it is stated that they were due to wanting or demanding any freedom for a particular.
Read para 36 and 37. Page 9.
This, we have mentioned that in paragraph 34, Prime Minister Nizam,
Address the people. I'm talking about read 36, 37.
yes, Hassan Ali has accepted the responsibility for the
Read
attacks.
para 36, please.
36. Mara populated 21 million residents, 70% were Biranis, and support for the BLL. And after the attacks attributed.
Read it properly. No?
Yes.
Again, read it again.
Mara populated by approximately 22.1 million residents, of which 70% were Birani, had already been experienced heightened political tensions. Support for Birani Liberation League remained high, and after attacks, attribution to radicalized Birani groups followed Hassan Ali's speech. Nizam publicly vowed that in a national address on 18th November 2023 that the justice of the state shall fall with a force never before witnessed in Aksha.
Next, 37.
Over ensuing 10 months, a pattern of systematic assaults unfolded across Mara, although government officials repeatedly asserted that the operation were directed solely at non-state militant cells. The resulting death toll exactly 1,89,762 individuals, overwhelmingly consisted of Birani civilians. Of these, the government internally classified 70,000 individuals as persons of interest or security aligned threats due to their alleged support for Hassan Ali's anti-government movement.
You killed 189,762 people, and you out of that 70,000 were referred to as personal interest security aligned threats.
Exactly.
Yani it was the total. How do you say that a genocide was not carried out in Mara area when your Mr. Nizam had asserted that the full force of the state will bear on that?
Your Excellencies, the count I will be referring to is murder and forcible transfer collectively.
Murder, genocide, murder ही होता होगा ना?
Genocide is a separate count, which is count 1, and murder is under the third count. Which is, we note that the civilians, the total death of persons was 1,89,762. My apologies.
Yes.
However, of these, the government had classified 70,000 as persons of interest, and the attacks were launched against them. The killings, the deaths of civilians, the remaining civilians, are regretfully, but however, we note that the government did not intend or directed an attack to them. The civilians were not the objective of the attack. We would like to mention the defense submits Katanga trial judgment, paragraph 100 and paragraph 1.
अब ये बताओ ना, देखो, the issue of murder is also crime against humanity.
Yes.
It's a very serious crime.
Exactly.
Genocide, and these are two very serious crimes under international law, right? इसमें you had killed more than one person. You get widespread systematic attack. What is your defense?
The widespread or systematic attack has to be directed against a civilian population.
What is your defense regarding these killings?
That the killings resulted from casualties and were not primary objective of the attack. If the facts are not fulfilling,
9,000 may say 70,000 people are person of interest. You are saying they are not. They are just casualties.
There are
70,000. You are saying people of interest.
Exactly. What we mention is that the civilians also, if we consider the word civilians, they have been aiding and abetting the militants by hiding weapon stockpiles and training camps.
That means you concede that the rest of the population was assisting the militants. Is that correct?
We do not concede that the entirety of the civilian population was assisting the militants. However, a major part might have been assisting.
If there was major part, then you justify your bombardment of those areas.
We mentioned that the militants residing in those areas were the target of the military. And in paragraph 56...
How could you distinguish from the aerial bombing which part of the area was militants and the civilians were different?
As per the ANA intelligence, as they have noted in multiple areas that they have found snipers, weapon stockpiles in civilian settlements, snipers on civilian rooftops.
How can you prove that they were not directed against civilians? They were not the target.
We proved that by noting down, we proved that by submitting that the ANA had evacuated 480,000 Birani civilians to safety camps to protect them from the crossfire itself.
During I concede to the displacement of those people.
No, we do not concede to the displacement. However, we note that they were transferred and evacuated to protect.
They were transferred with their consent?
Yes. They were not forced.
From your admitted facts, they were transferred with consent.
May I first...
you answer my question. Show that they were transferred with consent. And still 189,000 people were killed, despite 400,000 being removed.
Apologies.
Show me that they were with
they
their
would
consent,
like to
they
submit
were displaced.
Which is the criteria for coercion or expulsion within the means of ICC. We note that we draw comparison by the case of Kenya, the republic situation in Kenya, where in Your Excellencies, in situation of Kenya, the forcible transfer and expulsion of the civilians occurred by physical violence against them and burning of their houses and destruction of their property, sexual violence to forcibly evict women.
Same thing happened here in Barani areas. Forceful dispossession, burning of their houses, bombing of their houses. Your admitted facts say that.
Honorable Judges, none of these facts mention that any of these action occurred to coerce the population to evict.
Show me that you say that they had their consent. With their consent, you had removed them from those areas.
Honorable Judges, I would mention that in paragraph 56, it is noted that some civilians did refuse to move or transfer, and they were marked as
Persons of interest.
persons of interest. Exactly.
Fit for extermination. Fit for extermination.
That was not marked.
Please show me where. Kindly read this paragraph. Last three lines. Or
Last-
last 5 lines. Read.
Houses were marked with red paint to indicate security risk residence, which means that civilian
Destruction of the homes.
destruction.
The para 56 you referred to. Please read it.
Yes. A destructive wave of displacement occurred between July, September 24 and...
We have read
Ji.
that. The destruction, last 5 lines.
The destruction of homes, agricultural land and critical...
Satellite imagery later revealed.
Ji.
Satellite imagery later revealed.
Satellite imagery later revealed.
ऊपर से चपाती.
Satellite imagery later revealed that over 320 Birani villages were partly or fully destroyed during these months, primarily through controlled demolitions using C4 charges and incendiary devices deployed by engineering units. And
Yes,
judges, we mentioned
deployed by the engineering units.
Engineering
Your
units.
engineering units.
ANA.
Your ANA. You are ANA.
Akshar, yes. We note that the civilians were already evacuated from the zone.
Destruction of homes.
Agricultural land and critical infrastructure rendered return impossible, effectively transforming short-term displacement into
Permanent uprooting.
a permanent
आगे बढ़ो.
uprooting.
By the end of September.
By the end of September, an estimated 480,000 Biranis, one-third of Mara's population, had been rendered internally displaced, many surviving with minimal shelter, no legal documentation, and no foreseeable prospect of returning to their
How do you
ancestral
say
land.
this is by consent? This shows that it was your actions which rendered them impossible even to return to their homes. And they had to be internally displaced forcefully.
But as we mentioned that there was no coercion in evacuation.
You are bombing the place, you are using C4, which is the most...
After the civilians are evacuated to protection
And then you are
zones,
destroying their homes so that they can never return.
they were military objectives.
Those homes.
Yes.
Okay.
Because once the civilians are evacuated and the military operations
So then
are
it is
occurring,
international, it is justified to destroy the whole village or the city.
once it becomes a military objective, it does not hold protection of civilian homes and now becomes the military objective and can be destroyed.
It's a very dangerous argument.
Very dangerous argument.
It is. I
fighters
rely
against-
upon the rules of CIHL, Customary International Human.
Which rule is that?
Rule 8 and 9 and 10.
Yeah, they justify the destruction of those internally displaced people's homes.
Once the objective, the civilian homes become objective of military objectives
What was your objective?
to clear the
Just a minute.
insurgents, the
There is a
militants.
difference what you say. Military objective is between two opposing nations, not the same nation. Understand the difference between
The international armed conflict and non-international.
International conflicts constitutes a distinction between a dispute between two nations. Here it was same nation and you wanted to remove one part of that nation. How do you say that the rule will be applicable here? Because it's not a military operation. Technically, it is an operation
Anti-insurgency.
anti-insurgency. But
Your Excellencies, I would rely on Article 17 of Additional Protocol 2 of the Geneva Conventions, which allows in imperative military.
But excuse me, does Geneva Convention applies to internal conflicts within a nation?
The Geneva Convention, for its.
I'm not aware of it.
Yes.
I think you are misapplying the law.
Honorable, may I guide?
The Geneva Convention does have an issue internally, like
Exactly.
the Kashmir issue. There, the Kashmir issue is a non-state, and the Indians have taken over the non-state, and that is why Geneva Convention has been made applicable to them. Here, this is a state, not a non-state. There is a difference between the two. Try to understand the difference.
May
Because-
I,
yeah.
may
Go
I
ahead.
guide the bench on this matter? As I see my time is left, may I have a few minutes to
Yes,
finish my
yes.
submission?
Yes.
But the Geneva Convention does not apply on non-international armed conflicts such as the current one, as mentioned by
Then
Mr.
why are you
President.
citing it?
I'm citing is because Article 49 of the Geneva Convention allows
Read Article
Please.
17 of the Geneva Convention.
protocol.
Yes,
May I just finish one
Yes,
point and
yes.
then
Finish
read?
what you're saying, Jay.
On which Article 49 of the Geneva Conventions allows for civilian evacuations during imperative military operations.
In foreign
There is a
territory.
difference now.
Yes.
That is what I was trying to explain.
I am coming to that point, but that does not apply in our case. That does not apply because this is a non-international armed conflict.
If Geneva Convention does not apply, then what applies?
Protocol 2. Protocol 2, Article 17 was drafted to assist in similar cases where Geneva Convention does not apply due to the...
Read that.
I have the commentary on Article 17 as well, which states
The
this.
commentary is not the law.
Read Article 17 itself.
17.2 ये पढ़ रहा 17.1 and 2 देख लो जो अभी दिया गया है. What does it say? 17.2 ये ले लो, ये ले लीजिए इसको. Read the number 2, 17.2.
1 and 2 दोनों पढ़ लो.
Honorable judges, the one applies in our case.
नहीं apply कैसे करता है वो तो बाद में देखेंगे. Apply करता है
Yes.
क्योंकि how
The displacement of civilian population shall not be ordered for reasons related to conflict unless the security of the civilians involved or imperative military reasons so demand.
यहाँ please. What does the word conflict mean?
Conflict,
Yes.
armed conflict.
Armed conflict between two nations always. It is
nations,
never.
not within the nation.
Honorable judges,
Like
the,
if the Taliban who are fighting Pakistani forces, we are two nations are fighting each other? Or
the conflict
the
is
Geneva Convention will
the
apply
conflict is within the contracting party of the Geneva Convention.
here. Contracting parties
Internal-
are not always nations. They are countries who are contracting
Just a minute.
parties.
Just a minute. You have to understand that the protocol or the Geneva Convention is a contract between a state against another state, not internal. There is a difference between the two. When you say a contracted issue, then contract always is between the state, because as an individual in this country, I have no right to go to under the Geneva Convention under any protocol. I do not have the right. But a state can go against another state because it is a
Contracting
it is a contracting state. Now that is where you are making a mistake here. A very major mistake. You are referring to Article 17, 1 and 2. Article 17, 1 and 2 very categorical: displacement of civilian population shall not be ordered for it. And this was applied in the Security Council Resolution 47 of 1948. If you have read that resolution, this portion was applied there, and therefore they said you cannot remove a Kashmiri from his own house, and could not be removed. That is where this applies, because Kashmir was a non-state, and today it continues to be a non-state. You have to understand the difference between the application of a protocol, otherwise, or if you have something different.
may I clarify my point?
First of all, you must understand that this Geneva Convention does not apply.
I am explaining that the Geneva Convention, only the common Article 3, the ICC law regulates two types of conflicts. One is international armed conflicts and the other is non-international armed conflict. The non-international armed conflict is within the state as such in the present case.
यही मैं आपको अभी समझा रहा
जी.
था. Non-international conflict means something similar to the Kashmir conflict.
और ये पाकिस्तान में जो हो रहा है
The Kashmir conflict, if I'm understanding correctly, between Pakistan and India?
No,
within
no.
India के अंदर जो है.
It is whether the तभी कह रहा हूँ कि you have not read the Security Council Resolution 47 of 1948, where it says that they are protected people. There is a difference between the two. They are protected people, and no civilian can be removed from his protection. That is why the Kashmiris could not have been taken out, nor could anyone enter Kashmir as a resident. So that law that you are applying basically relates to only such a situation where it is not an international conflict. International conflict means between two states. But here there is a non-state and there is a state. It is not Pakistan and India.
The protocol I have provided, additional protocol 2 of the Geneva Conventions, is the para 1 is specifically drafted for non-international armed conflict.
आप सही कह रहे हो क्या? मेरी knowledge नहीं है इसके बारे में.
And thereby it allows civilian evacuation or transfer under imperative military conditions. This bench.
चलें, ठीक है. Move. Go ahead.
Honorable Judges, so the transfer of the civilians was under exception of international law as provided under Protocol 2, and therefore cannot.
Counsel, just for my own understanding, can you possibly displace people in Karachi to any other part of Pakistan and say the Geneva Convention applies?
Ma'am, if I take the example that when India attacked the Lahore border, the civilians can.
वो something
That is
else,
a totally
that will
different
protect,
issue.
वो तो उनकी
That is
safety
totally
के लिए
different.
बात
Can you repeat the question? I may understand
Can the
better.
people in Karachi, for any given reason, be relocated to any other part of Pakistan under the Geneva Convention?
Not under the. It depends on whether there is an international armed conflict or a non-international armed conflict.
चलें, ठीक है, आगे चलें.
But judges, we have noted that the defense established that there was no attack directed against primary civilians. The civilians were not the primary objective of the attack.
What was the primary objective of the attack then?
The militants, Birani specialists. If I may refer to the facts
So you
briefly.
concede that this was a targeted attack against the Iranis,
It was a targeted attack
which
against
brings
the
it very close
militants.
to genocide also.
Militants, not the Biranis. The attack was directed against the militants, and the militants happened to be from the Birani population. And the civilian casualties were also from the Birani population. This is because Marra was in fact 70% Biranis. And we note that the military operations, and I quote the words used by ANA to target their objectives, was non-state militant cells, armed Birani specialists, training camps, weapons, and Hassan aligned regrouping. These are the words which were used by the ANA to target their objective of the attack, and it was never noted that to be civilian.
So again, we conclude that the armed militants were primarily Biranis and militants or anybody who was supporting them.
Exactly.
Okay, so it was actually targeted towards the Biranis primarily. Because they, out of the major population that died, the largest numbers was the Biranis themselves, right?
They were not targeted because they were Biranis. That is the point I'm making. They were not targeted because of their ethnicity. They were targeted because they were terrorists. And they were non-state militant cells, as is stated by the ANA themselves. Judges, if I may.
See, there is a difference between the international humanitarian laws and the Geneva Convention or the Roman Statute. There is a difference between all three of them. Now you are trying to bring all of them together, which cannot, because under this the law, that is the customary international humanitarian law, this would apply to action within the country also, because this law is in relation to individuals and persons, right? Now, but this law is different from the Rome Statute, right?
Honorable Judges, all of the laws which I have mentioned are sources of law in this court, ICC.
So there may be sources of law, but what I'm trying to emphasize is that the Rome Statute is totally different from the humanitarian law. Because humanitarian law is applicable to individuals within the country also, right?
Yes.
But Rome Statute is not applicable to individuals within the country. There is a
Honorable
difference
Judges,
between
the charges brought to Prime Minister Nizam are under the Rome Statute, and the
Chale.
conflict also occurred within the country. Therefore, the Rome Statute is applied in the present case within the country of Akshar. There is no other country mentioned in all of the facts. The main armed conflict was between the Ashkar National Army, ANA, and the Brani Specialist
Which was a
Terrorists.
legitimate army of the state.
Give me an
Apologies?
Which was a legitimate army of the state.
It was a legitimate army of the state, according to...
Let me tell you. An individual, for instance, myself, I want to go to the ICC, International Criminal Court, and challenge Modi's action in Kashmir. Can I do it?
But Judges, the current
An individual, because Kashmir is not a state per se, it may be under there, but it is under the international conventions, right? Now, Modi has done a lot of genocidal acts there.
Gujarat.
Now, Gujarat nahi wahin par, for instance. Now, in Kashmir, if I want to go to the ICC as an individual, can I do that?
The exact procedure I'm not aware of, but the office
I'll
of the
tell you, I'll
prosecutor...
tell you. No, you cannot. An individual has no right. A state can go because the state is the signatory of the Rome Statute. A state, not the individual.
But the current...
Just a minute. So an individual within the state or two individuals within the state are not attracted, or this law is not
But
attracted.
there are
to them.
cases in the Bosnia conflict where individuals were allowed and they filed complaints. So in the Azerbaijani conflict, the individuals did go and challenge the crimes against humanity and genocide, etc. There are cases, you can find that.
See that you have to be very careful.
Honorable
when you are-
Judges, if you refer to paragraph page 14,
Can you conclude in 1 minute, please?
yes.
Conclude.
Honorable Judges, the defense has established that the primary objective of the attack was not the civilians. Therefore, the first contextual element here is failed, and Mohammad Nizam cannot be charged under Article 7, whether it be for forcible transfer or for murder.
What about 6?
Apologies.
What about 6?
My co-counsel has provided various sources of law and arguments to establish that Mohammad Nizam cannot be charged for genocide under Article 6, and we note that for superior responsibility, Prime Minister Nizam would also not be held liable because there is not a single order which he gave to the ANA command, and all of the commands to the ANA were given by Central Command of the ANA. It is mentioned in paragraph 58. Thereby, the defense prays to this honorable court to find that the prosecution has not established any sufficient grounds to confirm the charges against Prime Minister Nizam under Article 6 or 7 of the Rome Statute.
Thank you.
May it please the court, it was a pleasure to plead before you.
Thank you.
Where are you?
May it please the court. Your Honor, my opposing counsel just established that Nizam did not give any command to the army, but I would again want to rely on paragraph 59 that the commander seek clarification on the civilian casualties, and despite knowing the significant civilian casualties, he himself ordered that proceed civilian numbers are irrelevant. Other than that, the opposing counsel mentioned that the Biranis were not targeted based on their ethnicity, but Your Honor, I want, according to Article 6 of the Rome Statute, members of a protected group cannot be excluded based on their political affiliations.
What is protected group, ma'am?
That is under the Article 6 of the Rome Statute, that they're
तो होगा लेकिन क्या होता है
Protected group means a non-state, people living in a non-state. They are protected people under the United Nations resolution. So you have to understand the
Because
difference between a
because it says
protected
that
person. They are not protected.
It says
The
in your-
people
even your
staying,
issue.
they are the citizens of the state. They are not protected people. So don't go into that.
Okay, apologies, Your Honor.
Even your issue 1 in your thing says Barani people are constitute a protected ethnic group.
Yes.
So you cannot say they're not. They are.
Yes, they were an ethnic group. So here we protected by the Article 6 of the Rome Statute,
So
the
they are
four,
protected groups.
yes, national, ethnical, and religious and racial. Your Honor, even for the sake of argument, if we agree that they were military insurgents, the opposing counsel did not establish that those were proportionate. I have a case law on that. Can I refer that?
Yes.
Okay, my researcher will pass that on. It clearly says that military insurgents have to be proportionate.
Military.
Counterinsurgencies needs to
Measure.
be proportionate. May I proceed, Your Honor? Your Honor, my opposing counsel themselves acknowledged that homes were the primary objectives. Your Honor, I would like to bring to your kind notice that it is an important element of genocide, and we have a case law on that, that is Prosecutor versus Christich, that attacks on cultural and religious property when accompanied by physical destruction is a very compelling evidence for genocide. And here, the cultural attack was on their ancestral lands.
Thank you.
Thank you.
That's about it.
May it please the court.
Yes.
Honorable Judges, the counsel for the prosecution has argued.
Explain para 59, please, which they refer to.
Your Excellencies, para 59 refers to the internal situation brief which was given to the Prime Minister's office, and it stated about the majority, many of the civilian casualties in Zarna and Ruda, which were majority Biranis. And it also held a handwritten margin note, unsigned margin note, I might add, that the proceed civilian numbers are irrelevant if the area is secured. Do not delay operations over Birani losses.
Yes. So how do you justify that? Your internal memo.
I would justify it by proposing two arguments. The defense would propose two arguments. The primary argument is this is a margin note which is unsigned and it is unconfirmed or verified whether this was written by Prime Minister Nizam himself or not. And to use such...
It doesn't say it is written by Prime Minister. It is an internal situation brief to the office of the Prime Minister. So it's not written by the Prime Minister.
The margin note, Honorable Judges,
Margin note, who has written that margin note?
that cannot be verified. And that is precisely what I'm arguing as, because it cannot be verified that who has written this margin note, we cannot deduce...
But you did say 57, para 57. You admit to that.
Para 57?
GG.
And keep in mind, these are admitted facts from both sides also. These are the facts even you have
Admitted by
admitted.
both sides.
Precisely. The admitted facts are written, however, the interpretation is deferred
I
by...
agree with you there. It doesn't say that. ये जो leaked memo है ना
Leak.
इसके-
Exactly. Honorable Judges, under Article 69, sub-article 4 of the Rome Statute, the defense contends the relevance, admissibility...
Just one thing. You should explain that this para 57 does not mention that it was stated by the Prime Minister.
No, it does not state.
You should say it to us. Na, कि
It does not state who is the author or the source of this leaked directive. And it cannot be verified. And because it cannot be verified, it holds no probative value to be administered as evidence.
Thank you.
And the burden is on them, not you.
Precisely.
Thank you.
May it please the court. Thank you for your time.
Ryan? Yeah. क्या करें? Feedback मतलब?
तुम कर लो, मैं उससे बोला नहीं जाएगा.
अच्छा. अच्छा. Okay.
Prosecution has won the case.
Okay. Prosecution. Right. हम सब agree करते हैं prosecution. The feedback I've been asked to by the president and the other member of the bench to speak on their behalf. First of all, I'm very impressed. We are very impressed by your presentation. It was very good. And naturally, we were asking very difficult questions and you were answering very well. And we are very impressed. And you are yet not lawyers, but you are doing better than a lot of lawyers we know. So we all agree that the prosecution was able to convince us that Nizam had violated all the issues. So we support the prosecution. We give in favor decision in favor of the prosecution. But all of you, I don't know about others, but I am impressed by all of you, and I've given equal marks to all. So I do not know about them because I was convinced that the defense was also, they had a difficult case, but they argued very well, and I think you are doing well. Inshallah, you will succeed. You can also smile. Don't worry. You've lost, but you are very good. I've given you good marks. So and all the success for you. And the most important thing is that you have to convince the judge. You have the file, etc. You have to answer the questions succinctly and to the point. You had a difficult proposition because we were not, at least I was a little bit hampered by because I did some research on my own, but I was not provided with all the details. And next time if you invite somebody, you should also give the whole pamphlet. We were not given. So we do not, like memos hamare paas nahi the, so we do not know how to, you are referring to certain portions. And it is this topic itself is a very difficult topic of international law. And I'm really impressed by your presentation and your research. Even the case law you cited was not known to a lot of us personally. And I think you should keep it up, and good luck in your success and studies. कौन से स्कूल से थे? Which school do you represent? Ziauddin School. And you? Which school? Denning Law. I presided over Denning once, and that competition was also very good. But then 2-3 साल पहले, when I was the president of the bar, कोई Denning में हुआ था बड़ा जबरदस्त. Denning में? अच्छा, ट्रस्टी में.
As we now approach the concluding segment of the second National SZABIST Moot Court Competition 2025, it is a moment to pause and reflect upon the remarkable journey we have shared together. Over the course of this competition, we have witnessed exceptional advocacy, rigorous legal reasoning, and an unwavering commitment to the spirit of mooting. On behalf of SZABIST University, the Law Department, and the SZABIST Mooting Society, I extend my sincere gratitude to our honorable judges, esteemed faculty members, dedicated participants, organizers, and distinguished guests, whose presence and support have made this national competition a true success. To begin with our closing proceedings, I would like to invite Ms. Afifa Khalid, President of the SZABIST Mooting Society, to kindly come on stage and deliver her closing remarks.
Respected members of the faculty, honorable guests, dear participating teams, and my fellow members of the SZABIST Mooting Society. Assalamu alaikum. As we begin with our closing of the second SZABIST National Moot Court Competition 2025, I, Afifa Khalid, stand before you with the same pride and gratitude with which we began, now enriched by the experience of these past days. Over the course of this competition, we witnessed advocacy, sharp legal reasoning, professionalism, and an unwavering commitment to justice. I would like to extend my heartfelt gratitude to the people who made this event not just possible, but meaningful. Thank you, Ms. Asma Javed, Mr. Abid Zubairi, and Mr. Anwar Mansoor. Your mentorship, guidance, and generosity with your time has elevated every participant sitting here today. A special thank you to the Madam President, Madam Shinaz Wazir Ali, Dr. Professor Altaf Mukati. Your support for the student-led activities are empower us to work harder and bring events like these to life. I extend my deepest gratitude once again to our head of department, Ms. Zainab Fandi Haki, whose trust and support made this platform possible, and to our law faculty. Competition would not have reached this standard without them. To the participating team, you brought life to this moot. I also acknowledge the tireless effort of my mooting society, whose dedication behind the scenes formed the backbone of this event. Thank you all for being a part of this journey and for making the second SZABIST National Moot Court Competition a memorable and enriching experience. Thank you.
Thank you very much, Ms. Afifa, for those thoughtful and inspiring words. Next, it is my honor to invite Ms. Zainab Afandi Hakki, Head of the Department, SZABIST Law Department, to grace the stage and share her closing remarks.
Thank you, Ibrahim. Respected adjudicators, honorable chief guest, esteemed senior management and faculty members, dear students and participants, Assalamu alaikum and good afternoon. As we gather here today for the closing ceremony of our second National ZAB Moot Court Competition, it is a moment not only to conclude the event, but also to reflect the journey. A journey that began as a simple idea, which has now materialized into an experience rich with learning, growth, and collaboration. As Justice Oliver Wendell Jr. Holmes said, the life of the law has not been logic, it has been experience. Over the past few days, the competition has truly embodied that wisdom. It provided a forum where intellectual diversity and academic excellence of the legal profession across Pakistan were at the forefront. On this note, I would like to express my gratitude to all the institutions that have participated throughout this competition. Your participation reaffirms the importance of such competitions in the legal education. Now, on behalf of the Law Department, I would like to express our deepest gratitude to the advocates who agreed out of their demanding schedules to partake as adjudicators for this final round. Ms. Asma Javed, Mr. Abid Zubairi Sahab, Mr. Anwar Mansoor Sahab. Your guidance has greatly enriched the participants' experience, and it has certainly added immense value to our competition. On this note, I would also like to express our gratitude to our honorable chief guest, Justice Retired Nadeem Azhar Siddiqui Saab. Sir, your expertise and wisdom will certainly enrich our students and participants. And a special note of thanks to Mr. Salim Mangrio Saab, without whose guidance and support, this event, this venue would not have been possible. Though, what has made this event truly successful is not only the enthusiasm of our participants, but also the collective effort that has gone behind it. On this note, I would like to start by thanking my senior management, Madam Shinaz Wazir Ali, Professor Dr. Altaf Mukati Saab, Mr. Imtiaz Qazi Saab, as well as Madam Nasreen Haq. Without their continued support and encouragement, none of these initiatives would flourish as much as they have today. I would also like to express and appreciate the effort by our law department, the faculty members, as well as the staff, whose guidance and mentorship, as well as commitment to ensuring this competition met the highest academic standards. Thank you very much. Now, finally, a special word of appreciation is due to the Mooting Society, as well as the President, Ms. Afifa Khalid. Your tireless planning, coordination, and attention to detail transformed an idea into a well-executed reality. You have demonstrated dedication, commitment, and teamwork to legal excellence, qualities that will serve you all in your legal professional careers. As we bring this event to a close, let us remember that while we will recognize winners today, the true success of this mooting competition lies in the advocacy skills refined and the professional ethical values strengthened. I congratulate all the participants for their dedication, their perseverance, as well as their teamwork. And best of wishes to those who will be awarded later today. May this competition continue to inspire excellence and grow in stature in the years to come. Thank you very much.
Thank you, ma'am. We now move to a very special address. It is an absolute privilege for us to invite our keynote speaker, Justice Retired Nadeem Azhar Siddiqui, former Justice Sindh High Court and former Chairman of Tribunal Sindh Revenue Board.
Mr. Anwar Mansoor Khan, Mr. Abid Zawahiri, Ms. Asma Javed, the Honorable Judges, Ms. Zainab, HOD, faculty members, learned advocates, and dear students and participants of the moot court. Before proceeding my speech, I must say that I am not a chief guest, as Mr. Anwar Mansoor Khan, who is senior to me in all aspects, and in his presence, it is not good to call me as a chief guest, but I am here as a speaker. Thank you. It is a privilege to be with you today at the final round of SZABIST National Moot Court Competition 2025, hosted in this esteemed institution of justice, the Sindh High Court building. And I congratulate the SZABIST and its law department for reviving this national moot, for providing students a platform where classroom learning meets the living reality of the law. Moot courts are not merely competitions, they are training grounds for integrity, discipline, and ethical advocacy. They teach young minds that the law is not about winning arguments at any cost, but about serving justice with responsibility, clarity, and respect for the law. To the finalists who argued today, your preparation, confidence, and composure reflects not only intellectual ability, but also promise. Whether you received a trophy or not, remember this: every serious mooter leaves the courtroom sharper, humbler, and more aware of the weight that legal words may carry. As future members of the legal profession, you must remember that the law is a public trust. Titles, position, and success will follow, but character must lead. Our courts need advocates who are not only skilled, but also honest and ethical. I encourage you to continue reading widely, questioning deeply, and grounding your advocacy in fairness and in constitutional values. The strength of Pakistan's legal system tomorrow depends on the discipline and conscience of its lawyers today. Moot courts, as you all know, are not merely academic exercises. They teach you to think on your feet, how to argue without losing reason, and how to disagree without losing respect. These are not just courtroom skills, they are life skills for anyone who chooses to serve the law. During my years on the bench, I learned that the strength of an argument does not lie in its volume, but in the clarity, honesty, and grounding in principle. The best advocates I encountered were not those who spoke the most, but those who listened carefully to the law, to the facts, and sometimes even to the silence in the courtroom. As you prepare to step into professional life, allow me to share a thought that experience has reinforced time and again. The law is not merely a profession, it is a responsibility. From college to court, you will learn to navigate complex legal landscapes, argue with conviction, and advocate for justice. Your critical thinking, research, and communication skills honed over years will be put to a test. As you step into the courtroom, remember law is about people, not just papers. Empathy, integrity, and resilience will serve you well. Before I conclude, I would like to appreciate the faculty organizers, judges, and volunteers whose dedication made this event possible. Such initiatives shape out only careers but the future of our justice system. I congratulate the winners, uphold all participants, and wish each of you success in your academic and professional journey. May you carry forward the spirit of justice, integrity, and service wherever the Lord takes you. That's all. With this, I thank you all. Allah Hafiz.
Thank you, my lord, for your esteemed presence and for sharing your wisdom with us today. Lastly, I would like to invite Dr. Professor Altaf Mokati, Vice President, SZABIST University, Karachi, to kindly come forward and deliver his closing remarks.
Bismillahirrahmanirrahim. Honorable Keynote Speaker, Justice Retired Nadeem Azhar Siddiqui Sahab, Mr. Anwar Masood Sahab, Mr. Abi Zubairi Sahab, and Madam Asma Javed Saiba, all participating teams, faculty members, and students. On behalf of SZABIST University and its President, Madam Shanaz Wazir Ali, sitting here, I feel an immense pleasure to stand before you today to deliver the closing remarks for this truly inspiring 3-day second National Moot Court competition at SZABIST University. I am extremely thankful to our Law Society and our Law Department for organizing this mega event. Today I am very pleased to participate, to come into this competition to witness, and I was very, very pleased from the questions came from the respectable judges, brilliant questions, and even it enhanced my own personal knowledge. Although I am not a lawyer, I am just an engineer and vice president at academics at SZABIST University. Today, I came to know that what is the difference between terrorists and freedom fighters. I also came to know as a citizen of Pakistan, one cannot go to ICC on Kashmir issue against Modi. So these are the things, which are bugging me in mind for a long time, but today it is clarified by the brilliant questions asked. Now, since the arrival of Ms. Zainab Afindi, who is heading the department, the co-curricular activities of her department have regularly been organized, for which I must thank to her and her entire team. The significance of mooting competition is, of course, at the top of the list among co-curricular activities. The students are provided with an opportunity to demonstrate practically what they have learned during their studies. As we all know, mooting is an essential part of legal education. It bridges the gap between theory and practice. While textbooks teach students the principles of law, moot courts teach them how to apply those principles in real-world scenarios. At SZABIST University, all departments are encouraged to organize co-curricular and extracurricular activities throughout the year. Those who don't know much about SZABIST University, let me tell you about it very briefly. SZABIST University has 5 campuses. Karachi campus is the mother campus. The other campuses are in Islamabad, Larkana, Hyderabad, and Gharo. Our Gharo campus presents a state-of-the-art infrastructure. This campus is just an hour drive from Karachi airports towards the direction of Thatta. We offer 40 plus academic programs at the Karachi campus, from undergraduate to graduate and postgraduate programs in various disciplines. Our law department, what we call our regional training center, has been offering University of London LLB and Cert HE programs for more than 2 decades. In fact, we are the pioneer one in offering these programs in the city of Karachi. Coming back to the mooting competition, over the last 3 days, we witnessed a fascinating display of intellect, confidence, and advocacy. The teams from leading institutions such as Pakistan College of Law, Lahore University of Management Sciences, Zabul, Sindh Mehran Institute of Law, Jamshoro, Denning School of Law, Government Jinnah Law College, Hyderabad, Indus College of Law, Magister D. Lagam, and Ziauddin universities. Those are the participating teams over the last 3 days. They competed with passion and professionalism, presenting their arguments with remarkable composure and analytical precision. We are proudly honored by the presence of such a distinguished from legal fraternity, Justice Nadeem Azhar Siddiqui Sahab, Mr. Anwar Masood Sahab, Mr. Abid Zubairi Sahab, and Madam Asma Javed. To the winning team, I extend my heartiest congratulations. Your performance was outstanding and truly deserves this recognition. However, I must say that every participant today is a winner because each of you has gained something far more valuable than a trophy. You have gained experience, confidence, and a deeper understanding of what it means in legal education. As a concluding remark, I must extend my sincere thanks to Mr. Salim Mangario for graciously facilitating the venue. Your support played a crucial role in ensuring a smooth, professional, and welcoming environment to this national event. Once again, thanks to everyone who participated and helped us in organizing this event, particularly to our head of department, Mr. Zainab Afindi, Mr. Osama Surmawala, and other members of the team. Let us continue to uphold SZABIST University's tradition of excellence, where education goes beyond classrooms and learning transforms into leadership. Thank you all for being a part of this meaningful journey. Congratulations to the winners and runners-up, and to all our students for making this event such a success. Thank you, and may Allah bless you.
I would respectfully request Dr. Altaf Mukati to please remain on stage. And I would also like to invite Ms. Zainab Afandi Haqqi, Ms. Shehnaz Wazir Ali, and Justice Retired Nadeem Azhar Siddiqui to kindly join him on stage as we proceed with the presentation of Mementos of Appreciation. To begin, may I request Ms. Asma Javed, Senior Advocate, to kindly come forward to receive her memento. Next, I would like to invite Mr. Anwar Mansoor, former Attorney General of Pakistan, to the stage for his memento. Lastly, I now invite Mr. Abid Zubairi, former President, Supreme Court Bar Association of Pakistan, to kindly refuse it. We now move forward to the presentation of participation shields. I would request the teams to kindly come forward as their names are announced. Pakistan College of Law, Team BLL01. Shaheed Zulfikar Ali Bhutto, University of Law, Team EA03. Shaheed Zulfikar Ali Bhutto, University of Law, Team WA04. I think we don't have the team over here. Is anyone from WA04 present? Okay, we'll move forward with Sindh Mehran Institute of Law, Team MR05. Government Jinnah Law College, Team HA06. Indus College of Law, Team MN07. We will move forward with Ziauddin University, Team AAF08. SZABIST University, Team ANA09. Magister de Legum, Team OER10. Lahore University of Management Sciences, Team DS11. Denning School of Law, Team OST13. And Denning School of Law, Team OIH14. Congratulations to all participating teams for your dedication and commendable performance. We now arrive at the most awaited segment of this evening, the award ceremony. We will begin by announcing the award for Best Memorial. The award for Best Memorial goes to Team WA04 from Shaheed Zulfikar Ali Bhutto, University of Law. We now move on to the award for Best Researcher. The award for Best Researcher is presented to Ms. Fiza Majid from Team DS11, LUMS. And finally, the award for Best Speaker. The Best Speaker award goes to Mr. Ayan Khan from Team OST 13, Denning School of Law. And now it is my privilege to request the Justice Retired Nadeem Azhar Siddiqui Saab to kindly announce the runner-up team and the winner of the second National SZABIST Moot Court competition.
According to the results provided to me, the winner is OST 13 Denning Law School. And the runners-up is Team ARF 08 Ziauddin University.
Now I would like to call the Mooting Society, the team that with sheer dedication, passion and countless sleepless nights made this competition possible. After 13 years, they have successfully hosted the second National SZABIST Moot Court Competition 2025. Please give them a huge round of applause. Ms. Afifa Khalid, President of SZABIST Mooting Society. Marij Narejo, Vice President of SZABIST Mooting Society. Fajr Paracha, General Secretary of SZABIST Mooting Society. Royam Abbasi, Secretary Admin and Logistics. Deena Kazi, Secretary Media and Publication. Aisha Ibrahim, Academic Curator, SZABIST Mooting Society. Sheet Ahmed Siddiqui, Head of Curator, SZABIST Mooting Society. And lastly, Sheikh Ibrahim, the mooting mentor. Before we conclude, I would like to present a memento of appreciation to our Honorable Chief Guest, Justice Retired Nadeem Azhar Siddiqui Saab. Yes, sir. Ladies and gentlemen, on behalf of the SZABIST University, the Law Department, and the Mooting Society, I extend heartfelt thanks to our judges, guests, faculty members, organizers, volunteers, and most importantly, the participants who made this competition a true success. With this, we officially conclude the second National SZABIST Moot Court Competition 2025. We wish you safe travels and look forward to welcoming you again at SZABIST. Thank you and have a wonderful evening.